Welcome to the Deep Dive. Grab your favorite listening spot because today we're plunging into a fascinating corner of legal history, using a stack of your sources, a key court judgment, and some sharp analysis. We're here to unpack a courtroom battle that started with one man's job, but ended up shaping a crucial legal principle.
That's exactly right. The case is Brimson v. Rocla Concrete Pipes Ltd. And at its heart, it's the story of a long-serving employee, Mr. Brimson. He was, really close to hitting a major retirement benefit from his company's fund when, bam, he was suddenly let go.
Wow.
And his fight wasn't just about getting those benefits, though that was huge. It became this pivotal legal challenge asking, when can a court actually stop a case dead in its tracks, before the person even gets a proper chance to argue it at a full trial?
So our mission today is to follow this story right through the court system. We'll look at the initial challenge, the appeal, that landmark decision. And we want to meet the people involved, the employee, the company, the judges, and importantly, their legal teams.
Yes, understanding who is arguing what is key.
And we want to figure out why this specific case, heard decades ago, is still talked about, still cited in courts today. We're using the judgment from Justice Cross and that analysis document you shared to guide us through, well, every twist and turn.
Okay, sounds good. Let's start at the beginning then. Let's set the scene for Mr. Brimson and his time at Rocla Concrete Pipes.
Right. So Mr. Brimson was with the company for a long, long time. A dedicated employee from 1956 right through to 1981. That's, what, 25 years?
A quarter of a century. And he wasn't just clocking in and out. He worked his way up, eventually becoming the state manager for New South Wales back in September 1970, a senior role.
Definitely. And central to his future plans, it seems, was the company's Provident Fund. He'd joined that way back in 1958.
And the terms of this fund are absolutely critical here. The sources are very clear. If he stayed employed past his 55th birthday, which was June 16, 1984, he would become entitled to, and I quote, very substantial benefits from that fund.
Very substantial. But crucially, his employment ended abruptly in early 1981, well before that key date.
Yes. And he claimed this dismissal cost him dearly. Specifically, over $100,000 extra benefits that he expected to receive from the fund had he stayed on.
Over $100,000 back then. That's serious money.
Huge money. And what makes this situation particularly striking, according to the sources we have, are the circumstances around the dismissal. The judgment notes there was no evidence before this court that the company alleged any impropriety, misconduct, or incompetence on the part of the plaintiff.
So they weren't saying he did anything wrong. No bad performance, no misconduct.
Apparently not, based on what was before the court at that stage. And just as significantly, the source says, nor is there any evidence that the company advanced any reason whatsoever for its decision to dismiss him. Just gone.
Wow. So from Mr. Brimson's perspective, as his lawyers framed the case, this wasn't just, a standard redundancy or something.
No, he saw it, or at least argued it, as and this is his term from the claim, shoddy maneuver.
Right.
Basically, a deliberate tactic to avoid paying out those significant Provident Fund benefits he was so close to getting.
So how did he argue this legally?
Well, his primary argument was based on implied terms in his employment contract. Given his long, loyal service, 25 years, remember, and his reliance on those future fund benefits, he argued there were unwritten promises.
Like what?
Two main ones. First, that his employment wouldn't be terminated except for actual misconduct. And second, that the company wouldn't deliberately act in a way that would decrease or destroy his entitlement to those fund benefits.
Okay, that makes sense. Was there another argument too?
Yes, he had a fallback, an alternative claim. If the court decided those implied terms didn't exist, he argued the company was still obligated to give him reasonable notice of termination.
Standard stuff, right?
Well, yes and no. He argued that in his specific circumstances, the long service, the senior position, how incredibly close he was to that 55th birthday milestone and the massive payout reasonable notice had to mean something more. It had to be long enough to actually take him past June 16, 1984, securing those benefits.
Yeah, so reasonable had to cover that specific financial cliff edge he was facing.
That was the argument, a very specific definition of reasonable notice for his unique situation.
Okay, so Mr. Brimson files his claim, laying all this out. How does Rocla, the company, respond? Do they file a defense saying, no, that's wrong, here's why?
Well, that's where it gets interesting procedurally. Rocla Concrete Pipes Ltd. didn't immediately file a formal defense.
Okay.
Instead, they went on the offensive, legally speaking. This brings us to the first act, the first challenge, which happened in what are called the master's chambers, a level of the court system that handles preliminary issues.
And who are the legal players at this stage?
For Rocla, the defendant, their solicitors were A. Harvey Sutton & Co., based in Milson's Point. They used Sydney agents McGurran & Co., which was common. Their barrister was Mr. A.R. Ashburner.
And from Mr. Brimson?
The plaintiff, Mr. Brimson, was represented by the solicitors Carroll and O'Dea, and his barrister was Mr. P.J. Moss.
Right, got the teams. So Rocla, represented by Ashburner, instead of filing a defense, they did what?
They filed something called a notice of motion, asking that the plaintiff's statement of claim be struck out.
Striking out the statement of claim. What does that actually mean in plain English? Is it like throwing the case out?
That's pretty much it, yeah. It's a tactic to end the case very early. Rocla was basically asking the court, look at Mr. Brimson's written arguments. Even if you assume everything he says is true for a moment, he still doesn't have a proper legal case. Or letting him continue would be an abuse of the court's process, unfair to us. They wanted it shut down before it even got going.
Okay, a bold move. So this application came before a judicial officer called Master Allen. What did he decide?
Master Allen heard the arguments from both sides, from Mr. Ashburner for Riccia and Mr. Moss for Brimson, and he delivered his decision on December 18th, 1981. It was a bit of a mixed bag.
How so?
He looked closely at the first part of Mr. Brimson's claim, that argument about the implied promise not to dismiss him before 55 or mess with his benefits. Master Allen concluded that pursuing that specific claim would be an abuse of the process of the court.
An abuse of process. That sounds serious. Why did he think that?
His reasoning really hinged on the Provident Fund documents themselves, specifically a clause known as Rule 46.
Rule 46. What does it say?
It apparently stated quite clearly two things. First, that benefits from the fund couldn't be claimed as damages if someone sued for wrongful dismissal, and second, that the existence of the fund didn't limit the company's power to dismiss an employee. Master Allen essentially saw this rule as a brick wall, fatal to that part of Brimson's claim.
Okay, so Rule 46 seemed to directly contradict Brimson's argument about implied promises related to the fund.
That's how Master Allen saw it, yes. He felt that rule made that part of the claim legally unsustainable, an improper use of the court's time.
But you said it was a mixed bag. Did he let any part of the case go forward?
Yes, crucially, he did. He then looked at the second part of the claim, the alternative argument about needing reasonable notice that stretched past his 55th birthday. Master Allen found that part, although he described it as very weak, could still be argued. It wasn't completely shut down by Rule 46 in the same way, in his view.
So, weak, but not dead on arrival.
Okay.
Okay. How did his final order reflect this split decision?
Well, for neatness, Master Allen technically struck out the whole of the statement of claim. The original document was gone. But importantly, he immediately gave Mr. Brimson leave, permission essentially, to file a new amended statement of claim.
But only covering the reasonable notice part.
Exactly. Limited solely to that second argument about reasonable notice needing to extend past June 1984. He specifically mentioned he was acting under a procedural rule, Supreme Court Rules Part 15, Rule 26, when striking out the pleading.
So Mr. Brimson loses round one on the implied promise claim, but he still has a case, albeit a weakened one, based on reasonable notice. What's his next move? Does he accept this?
No, he doesn't. This leads us straight into Act 2. The Supreme Court appeal. Mr. Brimson wasn't willing to let go of that first, potentially more valuable part of his claim, the one about the implied promise tied to his age and the fund benefits. He decided to appeal Master Allen's decision to strike that part out. He took it up to a full Supreme Court judge.
Okay, he's fighting back. And what about Rocla? Did they use this opportunity to try and knock out the remaining reasonable notice claim that Master Allen had allowed?
That's a really interesting point. No, they didn't. Rocla did not file what's called a cross appeal. They didn't challenge the part of Master Allen's decision that let the reasonable notice claims survive.
So whatever happened with Brimson's appeal, Rocla was still facing some sort of potential trial down the track on the notice issue.
Precisely. That part of the case was now locked in to proceed, at least for the time being.
Right. Now, the legal teams for this appeal, did they stay the same?
Yes, the sources confirm continuity here. Representing the appellant, Mr. Brimson, were still solicitors Carroll and O'Dea, instructing barrister P.J. Moss. And for the respondent, Rocla, it remains solicitors A. Harvey Sutton Co., via their agents McGurran & Co., instructing barrister A.R. Ashburner.
Okay, same players, higher stakes, and the judge hearing this crucial appeal.
This was the Honorable Justice Cross.
Justice Cross. And his decision became pretty important, didn't it?
Hugely important. He heard the appeal relatively quickly on March 19th, 1982, and then delivered a very detailed, very considered judgment on April 30th, 1982. And yes, this judgment really dug deep into the whole question of when courts should use this power to stop a case early. It became a landmark.
He really unpacked the different ways a court can be asked to dismiss a case before it gets to trial, didn't he?
Yeah.
What was the key distinction he focused on?
Yes, he meticulously went through the procedural rules. He drew a really crucial distinction that, in his view, Master Allen had blurred. It's basically the difference between attacking the paperwork versus attacking the substance of the case.
Okay, paperwork versus substance. Explain that a bit more.
So attacking the pleading itself, the statement of claim, the written document is about whether it's technically defective on its face. Like, does it fail to properly state a known legal claim? Are there obvious drafting errors that make it nonsensical? There are specific rules, like Part 15, Rule 26, Master Allen cited, designed for fixing or striking out defective paperwork.
Right, so that's about the form, the way it's written.
Exactly. The other way, which is far more serious, is attacking the case itself, the underlying claim. This is where you argue that even if the paperwork is perfectly drafted, the claim is fundamentally doomed. It's hopeless, has absolutely no chance of succeeding, or it's frivolous, vexatious, meant to harass, or just an abuse of the court's process.
And courts have different powers for that.
Yes, they have specific rules for dismissing hopeless cases, like Part 13, Rule 5 mentioned in the judgment, or they can use their inherent power, this fundamental authority courts have, to protect their own processes and prevent injustice. It's a much higher bar.
Okay, so where did Justice Cross say Master Allen went wrong with this distinction in Brimson's case?
Justice Cross found that Master Allen had said he was using the rule for defective pleadings, P15R26. But Justice Cross looked at Mr. Brimson's statement of claim and said, actually, no, this does contain a properly formulated cause of action. The paperwork itself wasn't the problem. Master Allen's real reasoning, Justice Cross concluded, wasn't about defective drafting. It was about looking at the evidence, namely Rule 46 from the Provident Fund, and deciding that because of that rule, Mr. Brimson's case, the implied term part, was hopeless or an abusive process.
Ah, so Master Allen was making a judgment about the merits of the case based on evidence, but using the procedural tool meant for fixing bad paperwork.
Exactly. He used the wrong justification for his action, according to Justice Cross. And this mistake became the launching point for Justice Cross to strongly reaffirm a core principle of the justice system.
This is the really key part of the judgment, isn't it? The big principle.
Absolutely. He stated very forcefully what he called the fundamental principle, that a plaintiff, the person bringing the lawsuit, is prima facie entitled to have his case come to trial.
Prima facie, meaning, like, at first glance, the default position.
Yes. The starting assumption is you get your day in court, your right to have your story heard and evidence tested at a trial is fundamental. And crucially, Justice Cross stressed that this right should only be taken away in the clearest of cases.
Clearest of cases. That sounds like a really high standard. How clear does it have to be?
Exceptionally clear. Justice Cross didn't just invent this phrase. He drew on language from previous judgments to illustrate the point. He talked about cases that are so obviously untenable that it cannot possibly succeed, or manifestly groundless. Another description was so bad that no legitimate amendment could cure the defect.
So not just weak, but completely doomed from the start.
Precisely. And he explicitly quoted an earlier authority stating, the mere fact that the case is weak and not likely to succeed is not a ground for striking out a validly formulated pleading. That's critical. Just because you think the person might lose doesn't mean you stop them from trying unless their case is fundamentally, irredeemably flawed.
Okay,
Yeah.
So how did he apply this high clearest of cases standard back to Mr. Brimson's specific arguments, the ones Master Allen had struck out?
He reviewed the arguments that Mr. Brimson's barrister, Mr. Moss, had put forward about the implied terms, and importantly, how Rule 46 should be interpreted, or whether it even applied in these unique circumstances. Remember, Master Allen saw Rule 46 as a complete roadblock.
Right.
But Justice Cross looked at Mr. Moss's counter-arguments, ways to potentially get around Rule 46, perhaps by arguing it didn't cover this precise situation, or it should be read down in light of other contract principles or even public policy. And Justice Cross described these legal arguments as, and this is a great phrase, not intellectually disrespectable, and which just may happen to be correct.
Not intellectually disrespectable. That's quite the compliment from a judge, isn't it? means it's a proper legal argument, even if it's maybe novel or difficult.
Exactly. It means the arguments had substance. They were arguable points of law. They might ultimately fail at trial, but they weren't ridiculous or obviously wrong on their face. Therefore, Justice Cross concluded, Mr. Brimson's case on the implied terms was arguable. It was not transparently clear that he had no reasonable cause of action. It simply didn't meet that incredibly high clearest of cases test required to justify summary dismissal.
So the part of the claim Astor Allen threw out was back in because it was arguable, not hopeless.
Yes, but Justice Cross didn't stop there. He actually offered several other reasons why shutting down this part of the case early was inappropriate in these specific circumstances.
Oh, really? What else did he point to?
Well, one big thing was that Rocla hadn't actually filed a formal defense yet. They hadn't officially pleaded their reliance on Rule 46 as their answer to the claim.
Right, they jumped straight to trying to strike it out.
Exactly. And Justice Cross felt it was premature and improper to dismiss the case based on a defense Rule 46 that the company hadn't even formally committed to relying on at trial. He pointed out they might ultimately decide not to rely on it, perhaps for industrial relations or because of some other considerations. You couldn't just assume they would.
Interesting. So you can't knock out a claim based on a defense the other side hasn't even formally raised yet?
Not usually, not at this summary stage. Another point he made was about efficiency, ironically. Remember, Rocla hadn't appealed the part of Master Allen's decision allowing the reasonable notice claim.
Yes, so some kind of trial was going to happen anyway.
Right. Justice Cross reasoned that since a trial was already inevitable on the reasonable notice issue, allowing the other claims, the implied term ones, to be heard at the same time wouldn't actually cause much additional hassle or prejudice to Rocla. Why have two potential sets of proceedings when you could deal with it all at once?
Makes sense. Any other reasons?
Yes, one final important point about appeal rights. Justice Cross noted that if a case is summarily dismissed, the plaintiff's ability to appeal that decision and challenge the legal reasoning is often more restricted than if the case had gone to a full trial, where all the facts and legal arguments are fully explored and put on the record.
Ah, so a full trial creates a better foundation for potential appeals later on.
Yes, especially if there are complex or developing areas of law involved. Justice Cross actually mentioned a then-recent English case called Gunton, which dealt with wrongful dismissal damages, suggesting the law in this area might be evolving. He hinted that these were potentially complex issues the High Court of Australia might need to consider eventually, and a full trial record would be essential for that. It reinforced the idea that complex, arguable points should be tested at trial, not shut down prematurely.
Okay, so a whole raft of reasons pointing towards letting the case proceed. Yep. Given all that, what was Justice Cross's final decision on April 30, 1982?
The result was clear. The appeal was allowed. Master Allen's order striking out Mr. Brimson's statement of claim was set aside, completely overturned.
And costs. Usually the loser pays.
Correct. Rocla Concrete Pipes Ltd. was ordered to pay Mr. Brimson's legal costs for the appeal.
So the practical effect was a big win for Mr. Brimson at this stage. His case was back on track.
Absolutely. His full original statement of claim, including both his main argument about the implied terms relating to his job security and benefits, and his alternative argument about reasonable notice extending past 55, was fully reinstated. He had successfully fought off the attempt to derail his case early and won his right to have all his arguments heard.
A major procedural victory for him and his legal team. So, after this win in the Supreme Court appeal, what happens next in the life of this lawsuit? Where does it go from here?
Okay, so procedurally, the case essentially gets sent back down the line. With the statement of claim now fully reinstated, the ball was back in Rocla's court. The next logical step would be for Rocla to finally file their formal defense,
where they'd actually have to respond to all of Mr. Brimson's claims, including the implied terms and the Rule 46 argument.
Precisely. They'd have to lay out their side of the story formally. After that, you'd typically move into pretrial stages like discovery, where both sides have to show each other relevant documents, maybe witness statements, and generally preparing for a potential full trial where evidence is presented, witnesses are cross-examined, and a judge makes a final decision on the merits.
Do we actually know if it ever got that far? Did it go to trial? Did they settle? The sources we have, the judgment and the analysis, they focus on this procedural appeal, right?
That's the limitation, yes. These sources give us a fantastic, detailed picture of this crucial procedural battle and the legal principles established by Justice Cross. But they don't tell us the ultimate substantive outcome of Mr. Brimson's claim.
So we don't know if he eventually got that $100,000 plus.
We don't. We know he won the right to try, but whether the case went all the way to a final judgment or whether the parties perhaps reached a confidential settlement out of court, which often happens in these types of disputes, or if it resolves some other way, we just can't tell from this material. So, the end of Mr. Brimson's personal story, in terms of the final outcome, remains, well, an unfinished one based on what we have here.
Frustrating. But we do know the legal team stuck with it through this appeal phase.
Yes. The sources confirm the same solicitors and barristers, Carolyn O'Dea and P.J. Moss for Brimson, a Harvey Sutton & Co. with McGurran & Co., and A.R. Ashburner for Rocla were involved throughout these documented proceedings.
Okay. Before we dig into the lasting impact of Justice Cross's decision, let's quickly recap the key people involved, the dramatis persona, as you call them, just based on what our sources tell us.
Good idea. So, first and foremost, Mr. Brimson, the plaintiff, what we know is 25 years of service, rose to NSW state manager, dismissed shortly before his 55th birthday, and a big Provident Fund payout. He clearly felt wronged and showed real determination in pursuing his claim through the courts, including the successful appeal.
Then the defendant, Rocla Concrete Pipes Ltd., the employer, took an assertive legal strategy trying to get the case struck out early, relying heavily on the wording of their Provident Fund rules.
Then the judicial officers. First, Master Allen. He heard the initial strikeout application, made that complex split decision striking out the implied term claim based on Rule 46, but allowing the reasonable notice claim, albeit calling it weak. His reasoning on the strikeout was ultimately overturned. The sources don't give much more biographical detail.
And the judge who heard the appeal, the Honorable Justice Cross, he was sitting in the Supreme Court's Common Law Division. His detailed, carefully reasoned judgment, clarifying the rules for summary dismissal and defending the right to trial, is the reason we're talking about this case today.
Absolutely. Then the barristers. For Mr. Brimson, the appellant, P.J. Moss, his legal arguments were specifically praised by Justice Cross as being not intellectually disrespectable, which was key to winning the appeal. The analysis we have raises the interesting possibility this might be the P.J. Moss who later became a prominent QC and a judge himself.
And for Rocla, the respondent, A.R. Ashburner, he argued forcefully for the strikeout application before both Master Allen and Justice Cross, focusing on the effect of Rule 46. Again, limited personal info in the sources.
And finally, the solicitors instructing the barristers. For Mr. Brimson, the firm Carolyn O'Dea, described as a long-established firm since 1899, often representing individuals in disputes, including compensation claims, which fits the picture here.
And for Rocla, a Harvey Sutton Co. from Milson's Point, using their Sydney agents McGurran & Co. The sources no less is readily known about this firm from the time, and again, using city agents was standard practice.
So you have this whole cast, the individual, the company, the lawyers, the judges, all playing their part in a case that, while focused on one man's job, ended up having much broader significance.
Okay, let's talk about that significance. Why does Brimson v. Rocla Concrete Pipes Ltd., this case from the early 80s, still matter? What's its enduring legacy?
Well, its primary legacy is definitely in the realm of civil procedure, the rules of how court cases are run, particularly in New South Wales, but its influence is felt more widely. As the analysis source puts it, its most profound impact is its really robust defense of a plaintiff's right to have their case heard at trial.
It's the case people point to for that exceptionally high threshold for throwing a case out early.
Exactly. It cemented the principle that summary dismissal, striking out a claim because it seems hopeless, is an extreme measure. It should only happen in the absolute clearest of cases. You don't do it just because a claim looks weak or unlikely to succeed.
And this isn't just some dusty old principle, it's actively used.
Oh, absolutely. Brimson is cited constantly. It's referenced in things like the official bench book that judges in NSW use for guidance in civil trials. You see it mentioned in legal articles as a key, sometimes the best known, example of this principle. And importantly, subsequent court judgments, like a later Supreme Court case called Spencer, explicitly rely on Brimson to reaffirm that you only dismiss a case or strike out a pleading if it's absolutely hopeless and fundamentally beyond saving by legitimate amendment.
So its authority on that core point remains really strong. Did it clarify anything else procedurally?
Yes, that distinction Justice Cross made between attacking the pleading, the document, under rules like P15R26 versus attacking the case itself, hopelessness abusive process under P13R5 or the inherent jurisdiction, that clarification was incredibly useful. It provides guidance on when the right response is maybe to allow an amendment to fix a poorly drafted claim versus when the claim itself is so flawed it has to be dismissed entirely. There are legal practice papers that cite Brimson specifically for that point. If you can discern a potentially viable cause of action, even if badly expressed, give them a chance to fix it.
Okay, and beyond pure procedure, given the facts involved Mr. Brimson's job and the fund, did it have any ripples in employment law?
It's perhaps more subtle there. Its main fame is procedural. But you could say Justice Cross's decision to let Brimson's arguments about the implied terms and the fund rules go to trial, despite the seemingly clear wording of Rule 46, signals a certain judicial reluctance. A reluctance to let standard clauses, boilerplate stuff in contracts or fund rules, automatically extinguish potentially arguable employee claims without full examination of the specific facts and context at a trial.
So not letting the fine print automatically win without a fight.
Kind of. And his mention of the developing English law, the Gunton case, also suggests an awareness that the legal landscape around employment rights and dismissal damages was shifting, potentially becoming more complex, which again favored giving these issues a full hearing rather than a quick dismissal.
Right. It sounds like the case really highlights the court's role as a gatekeeper almost.
That's a great way to put it. The judiciary has this crucial gatekeeping function. They need to ensure the courts aren't clogged with completely meritless claims, protecting defendants from vexatious litigation and managing resources. That pushes towards efficiency. But on the other hand, they have a fundamental duty to ensure access to justice, to make sure people with arguable claims get their day in court.
It's a balancing act.
It's a huge balancing act, and Justice Cross's judgment in Brimson came down very firmly on the side of protecting that access to justice. It emphasized that the balance tips towards letting a case proceed unless it meets that extremely high bar of being utterly hopeless. And that's particularly vital, you could argue, in situations where there might be a power imbalance, like an individual employee taking on a large corporation.
So wrapping this up, Brimson v. Rocla Concrete Pipes Ltd. started as one man's fight over, well, what he felt were unfairly lost retirement benefits, but it became so much more. It was this critical moment for clarifying exactly when a court can justly close its doors to someone trying to bring a case.
Absolutely. Justice Cross's judgment is this powerful reminder that just having what looks like a weak case isn't enough. It's not the same as having a hopeless case. The bar for summary dismissal, for denying someone their chance to argue their case fully, was set and reaffirmed as being exceptionally high, and arguably it should remain that way.
It really is fascinating, isn't it, to see how Mr. Brimson's personal determination, his decision to appeal that initial setback, despite facing a big company, directly contributed to establishing such a significant legal principle.
Yeah.
A principle that protects the access of countless others to the courts today.
It's a great example of how individual cases can shape the law. So, as you reflect on this deep dive, maybe think about the importance of these procedural rules we've been discussing. How exactly do they work to safeguard individuals, especially when they might be up against powerful entities? And perhaps consider where you think that line should be drawn, the balance between court efficiency and ensuring everyone truly gets fair access to justice. It's a fundamental tension, really, right at the heart of our legal system.